Yes.
My lord, you should have, just a matter of housekeeping, I promised the FTT directions you should have in front of you.
Yeah, that's very kind, thank you.
A copy of those. Thank you. That's the two sets. If I may, I have no intention of reopening the section 18 point, but I think it's important to give you the upper tribunal references I had promised, which is full bundle, page 46, tab 4.
Did you want to look at the FTT decision as well, or just the upper tribunal?
No, it's just to finish off on the section 18 point.
Oh, I see.
Just to make sure the court had the references. I don't intend reopening
So,
it.
I'm sorry, I missed that. If you could give me that again, please.
Yes, my lord. Tab 4,
Yep.
page 46.
Yep.
And it's paragraphs 51 and 52. And your lordship will see this is where the upper tribunal deals with the interaction link between the two issues of admissibility and disclosure, and looking at Rule 27, but in particular at paragraph 52, they say in most straightforward situations involving a dispute between a single taxpayer and HMRC, there may be no practical incentive to argue that particular documents should not appear on HMRC's list. Most of those documents will already be known to the taxpayer. Many indeed will have been provided by the taxpayer in the course of HMRC inquiries leading up to the decision in dispute. Nevertheless, we accept that if HMRC purported to include irrelevant documents in a list of documents, the FTT has power to intervene and direct that the documents should be removed from the list. If it does say the usual obligation of Rule 27 to provide other parties with copies of the documents or the ability to inspect them would fall away.
So could I ask you two brief questions about that?
Yes,
firstly, we can see there's no reference there to section 18. Is it referred to elsewhere in the decision?
My lord, yes, at paragraph 15, at page 39, they set out the FTT's referral to section 18 of the 2005 Act. Then they go to paragraph 16, and they refer to an extract of Lord Toulson's decision in Genius. Then 17, they refer to what the FTT said on the matter. I was not called upon to determine the exact boundaries of the exceptions in the Lordship. The court can see that. Paragraph 18, pausing there, this passage shows that the FTT was approaching matters as if the question whether HMRC should disclose documents to Mr. Bell was parasitic on the question whether HMRC would be entitled to rely on those documents as evidence, so that one, if HMRC was entitled to rely on them, they should be disclosed, but two, if HMRC were not entitled to rely on them, they should not be disclosed. Such an approach left no room for a third possibility, namely that there were some documents that should be disclosed to Mr. Bell, even if HMRC were not entitled to rely on them as evidence. We return to the significance of this point when considering the detailed grounds of appeal. That's then goes through to paragraph 51 and 52.
So that leads to my second question is, in paragraph 52, the upper tribunal says in the penultimate sentence you read to us, we accept that if HMRC purported to include irrelevant documents in a list of documents, the FTT has power to intervene and direct that documents should be removed from the list. Now, that sentence on its own doesn't identify the source of that power. What in your submission was the UT contemplating as being the source of that power?
My lord, they must have had in mind, in our respectful submission, what they say at paragraph 14, page 39, that they set out. The FTT considered the legal principles at 18 to 32 of the decision. FTT noted its powers to direct disclosure and to exclude evidence under Rule 53D and Rule 15.2b of the First Tier Tribunal rules.
I'm sorry, I must be looking in the wrong place. Where were you referring to?
My lord, paragraph 14, page 39, full bundle.
So your submission is that in paragraph 52, the power that the UT is referring to is either by 3D or 15.2b?
My lord, yes, and at the risk of giving you another reference, which is the case, page 43, paragraph 33, under the heading Relevant Provisions of the Rules, parties are agreed that the FTT had power by Rule 53D and Rule 15.2b of the rules to grant either or both HMRC's application and Mr Mitchell's application. In particular, by Rule 15.2b, the FTT had power to admit or exclude evidence, including power to exclude evidence which would otherwise be admissible, but would otherwise be unfair to admit the evidence. And then,
well, that doesn't seem quite to marry up, does it? Because that's talking about exclusion of evidence, whereas in paragraph 52, the UT is talking about directing that documents be removed from a list.
my lord, yes, and if I pick up at paragraph 53, the UT decision, page 46. And it's the point which I submitted this morning, which is, this is Mr Mitchell's first argument, is that level 2C and level 3 documents are necessarily irrelevant to these proceedings because those documents by definition do not relate to the universal companies in respect of whose affairs HMRC can place the PLN. The tribunal then goes to Randall, which this court will be well aware of in terms of admissibility. And
well,
then,
to be sure, but that's talking about their judgment on relevance versus irrelevance, as I understand it. But what they say in paragraph 52 is predicated upon the documents being irrelevant.
yes, and going then to paragraph 65, page 48, the UT decision, they say the FTT recognise there are circumstances where relevant evidence may be excluded and cited what new GJs then was said in IA Associates. And then at 66, there is an issue in this appeal to the extent Mr Hickey's should be excluded. We've already quoted from paragraph 31 of the decision in which FTT set out its understanding that Mr Mitchell was not advancing a fallback argument to that effect. Even if documents were relevant, the FTT should nonetheless exercise its power under Rule 15.2b3 of the rules to exclude it.
So, in your submission, the reasoning there is that if evidence is to be excluded under Rule 15.2b3, it follows that the documents cannot be produced in the first place. Is that the reason?
My lord, yes. That's the submission we made in the FTT and upper tribunal. And as part of that, this is why the upper tribunal, if I can refer you to paragraph 59, page 47, Mr Mitchell correctly emphasised the important function that statement of cases perform in both courts and the tribunals. He then refers, the upper tribunal then refers to Burns, and then IA Associates, new GJs, he then will said at 33 that when dealing with an application of specific legislation, the test of relevance must be applied, as you can see. 60, however, HMRC...
Sorry, just before you go on,
Sorry.
Can you assist me on this? First of all, that's obviously in the context of an application for specific disclosure. And so my first question is, well, what's the relevance of that to our situation? But also, in the passage that's quoted, reference is made to the issues and asserted facts as identified from each party's pleaded case. How does that work, where you've only got statements of case from one side and not the other?
In our respectful submission, the answer is provided by paragraph 60. The upper tribunal's decision, if I may. However, HMRC's statement of case was not the only articulation of the party's position that was relevant. There was also Mr. Mitchell's and Mr. Bell's positions set out in their grounds of appeal to consider. Mr. Mitchell's grounds, notified to the FTT in particular, were too brief that they gave no real indication of the kind of case he would be making. The FTT was therefore entitled to have regard to the explanations they gave at the hearing as to how they would be making their respective cases. I do need to point out to the court that if you go to page 44 and paragraph 39, the upper tribunal was well aware of the following. Paragraph 40, Mr. Bell contends that he took no active role in running companies. Wrong citation, paragraph 39. Mr. Mitchell simply stated that he did not agree with HMRC's decision that he was a shadow director of the Universal Companies, and 2, that the VAT inaccuracies were on such a scale that he could not have been unaware of them. Footnote 1. BDO had given HMRC full particulars of Mr. Mitchell's case in a letter dated 5th of January 2018, appealing against and requesting a review of HMRC's decision to issue him with a PLN. However, that letter was not referred to or attached when Mr. Mitchell notified his appeal to the FTT. The FTT referred at 33 of the decision to the relative lack of detail in both Mr. Mitchell and Mr. Bell's grounds of appeal.
So, for all of the heat about the importance of statements of case, pleadings, in fact, what the upper tribunal did was say at paragraph 61, over the page 48, that the First Tier Tribunal had been entirely entitled to go outside the statements of case and proceed in order to identify relevance or determine relevance on the basis of oral, unsubstantiated submissions made before them as to the nature of the cases to be advanced.
Well, the focus, we'll go to the FTT decision, had been on HMRC's statement of case, but the FTT has wide discretion, as this court is well aware, in how to deal with a case management decision, and we make no complaint about the tribunal judge considering both what was in the notices of appeal and also the submissions made by my learned friend in relating to the nature of Mr. Bell's defence. There's the related point that, as I said in my submissions this morning in relation to HMRC's statement of case, that is formulated against the backdrop of sight of HMRC's original decision, their review decision, and of course the review decision is on the basis of, and the reviewing officer will have seen the full BDO.
Well, to be sure, as you explained this morning, this has got a long history, and therefore HMRC are well informed as to relevant facts and matters. I take that point.
Yes.
But nevertheless, you're not submitting that the tribunals were confined to HMRC's statement of case.
No.
Right. So what's the limit of the inquiry then, if they're not confined to HMRC's statement of case?
Well, it's HMRC who issue the PLN, and it's HMRC seeking to impose the liability when the statement of case is issued. That is the most important document vis-à-vis the taxpayer and HMRC, because it's the taxpayer who has to defend against PLN and seek its discharge, and the taxpayer's evidence and arguments will be formulated by reference to the case which has been formulated and articulated in the revenue statement of case. Once you have that statement of case, as I said this morning, it will then dictate the future direction of travel and the usual course of events for disclosure under Rule 27. In terms of the grounds of appeal, the HMRC's statement of case will be formulated by reference to those grounds, but also the wider history, because the statement of case is going to be formulated by the decision letter or any reviewing officer's decision, and all of that is informed by the wider particulars which are given by a taxpayer. So in many respects, HMRC's statement of case is the most important document.
No doubt, but what's the limit on the inquiry? Because for the reasons you give, HMRC statement of case, undoubtedly important document. But in answer to my previous question, you accepted that the FTT was not limited to the HMRC statement of case. So what is the limit?
Would this be an appropriate moment to actually go through the FTT decision on level 2B and level 4? Because that reflects.
Could you not give me an answer to the question first?
Yes, well, the answer to the question is that the First Tier Tribunal starts with the revenue statement of case. And the question then is, what are the four corners of the revenue statement of case in terms of the law and the facts, in terms of the issues of fact in dispute? So in this particular instance, it's it's the liability of the appellants to personal liability notices. And the key question there is, was there a VAT insufficiency which has been deliberately brought about by filing incorrect returns? Second, are each of the appellants shadow directors? And third, is the tax insufficiency, the deliberate conduct, attributable to the shadow directors? Those are the core questions of fact which will have to be dealt
I'm
with.
very sorry, I must be being dense. I do apologise, but I'm failing to understand what the answer you're giving to my question is. Because you accept that the FTT was not confined to the revenue statement of case. So what is the limit of the inquiry?
The limit of the inquiry is, I think, well, in my submission, it is fact specific. It's determined by all the circumstances that a first tier tribunal judge is faced with in order to determine whether or not to permit an application either to exclude evidence under Rule 15 or to allow an application for specific disclosure. And in each case, the tribunal judge has to say to himself or herself, what is the relevance of the evidence either being sought to be excluded or to be sought pursuant to a specific disclosure application.
And in your submission, what is the correct test of relevance?
My lord, the correct test of relevance is as set out by the House of Lords in Kilburn and also in Randall, but I think if I just go straight to Randall, Legal Authority Bundle, tab 3, page 62, and page 68. Judgment of Lord Steen. Under the heading Relevance. It's paragraph 20B through to G, and it's encapsulated at G. A judge ruling on a point of admissibility involving an issue of relevance has to decide whether the relevance is capable of increasing or diminishing the probability of the existence of a fact in issue. The question of relevance is typically a matter of degree to be determined for the most part by common sense and experience.
So, Lord Steyn there refers to increasing or diminishing the probability of the existence of a fact in issue. How does one decide what facts are in issue if you are not limited to HMRC statement of case?
Because HMRC's statement of case is going to be drafted on the basis that it is responding to the grounds of appeal filed by each appellant, and HMRC's case is going to be informed by two pivotal documents. One, typically a decision letter, and then a letter from a reviewing officer. And so in terms of the revenues case, that's going to be by reference to the law and the facts. So the law here, I mean, would this be convenient to take you to the revenue statement of case because it sets out the law, the very clear issues? And
Well, but by all means do that. But whenever I ask you the question, you always refer to HMRC statement of case. And of course, I take your point. It's a central document. And I could understand if you made the submission that what is in issue can only be judged by reference to HMRC statement of case. But you have accepted the FTT was not confined to that. And therefore I'm puzzling as to how you say one judges what is in issue in circumstances where we don't have statements of case from either of the appellants.
I don't think I can add to anything further, my lord.
Well, what the upper tribunal did at paragraph 62 was conclude that the first tier tribunal's approach, namely to judge reasonableness, relevance, by reference both to the parties' pleaded cases and also, quote, the appellant's explanations given at the hearing as to how they expected to advance their appeals. And your position is that was perfectly acceptable approach.
Yes.
So is that fair?
It is.
So you say the test is statements of case, and in circumstances where the appellant's cases are very briefly pleaded, entitled to take into account for the purpose of assessing relevance the explanations given at the hearing as to how the appeals were expected, quote, to be advanced. Yeah.
Yes.
Is that's?
It is. Sorry, I didn't go to the option.
No, I just wanted to think that's
confining myself to
where I've been looking.
Very good. So you were offering to take us to the statement of case, and
Look,
by all means do so if that's of assistance.
I think we were on the upper tribunal.
Yes.
Oh,
There was an offer a couple of offers ago to go to the first tier tribunal. I was going to put in a bid to stay with the upper tribunal if we could, just to do that all at once, if we may.
Yes.
And the points that I wanted, I picked up your submission just now, and I've got it well in mind, that the question for the judge is what's the relevance of the evidence.
Yes.
And I just wanted to look at how the UT dealt with this in terms of the actual categories of documents they were looking at. So page 52, we start with level 2B and level 3 documents. Page 52, it starts at about...
One might start...
Do you want to go somewhere? You
No.
take me where you want to. I think you know where I want to go in the end. It's the UT's conclusions about these documents.
Against the backdrop of having gone through at page 43, the relevant provision of the rules.
Yeah.
Then at page 44, the role of pleadings in tax proceedings.
Yep.
And the upper tribunal very fully goes through part of HMRC's case against each of the appellants and identifies, as the First Tier Tribunal did, and this is paragraph 42, that the input VAT, which was denied and has resulted in the PLNs, relates to supplies by only two companies called Margall and Arion, and those were companies, as you can see in the middle of that paragraph, controlled, partly owned and controlled by Mr. Bell. And the point to highlight, because this is a central feature of both the FTT and the upper tribunal going through the pleadings, and also both Judge Mosedale and the upper tribunal considering the levels of relevance, particularly on level 2B, which is there's only a limited number of companies involved. You have Universal Projects and the second Universal company, Universal Payroll, thank you. You have two individuals, Mr. Bell and Mr. Mitchell, who are both shareholders in each of those companies. You have a further two companies, which are Margol and Arion, which are the companies which have resulted in the disallowed VAT, which have given rise.
The supplier companies, aren't
That's
they?
right.
Marvel
Those
and
were the
Ariel.
supplying companies. Had issued invoices. The invoices had not been paid by Universal, so the credit for the input tax had been claimed, but the invoices
But
hadn't been
no
paid.
output tax had ever been accounted for.
Precisely, my lady, and that gave rise to the PLNs. So it's very important not to lose sight of who the players are, if I can use that term, because those are the only entities and individuals involved, in addition to one further person, an individual called Mr. Bounds, who's referred to expressly in HMRC's statement of case, and he was a director of record for the companies. And as you'll see...
What about Mr. Bansal?
Sorry, and Mr. Bansal, he was the accountant. But in terms of the question of who was the director, it would have been Mr. Bounds of record at the relevant time. Then the question is, were either Mr. Bound or Mr. Mitchell shadow directors? So they had in mind from 37 through to 46 the pleadings and HMRC's position in order to establish the validity of the PLNs. And then if you go to just focusing on level 2B, just to remind the court, level 2B is any mention of interaction between the universal companies or either of them with other companies controlled or allegedly controlled by Mr. Mitchell and or Mr. Bell. That is how HMRC sought to put level 2B, and you can see that at paragraph, sorry, yes, that's at paragraph 10, page 38, and in fact level 2B is set out at page 39. So that's how HMRC sought to put the level of relevance. And then Judge Mosedale at paragraph, what I call 64A, because you've got paragraph, in the FTT decision it goes 63, 64, but in between you've got a paragraph, and Judge Mosedale said, yes, level 2B relevant, but with this limitation, only relevant and admissible on the current pleadings to the extent refers to companies mentioned.
That's in her concluding bit, is it?
Yes.
Yep. Can we stick with the upper tribunal
Yes.
for the moment, please? Just because it's easier to follow. And the particular passage that I wanted to ask you about, I can just put the question, then you can say to me if you want to take me to more background
Yes.
and take a longer run up to it.
Sure.
But we have level 2B and level 3 dealt with on page 52. This is part of the dismissal of Mr. Bell's appeal.
Yes.
It seems to me this is where the guts of the decision was. And at paragraph 90, the upper tribunal says, taking into account the parties pleaded cases and the information Mr. Bell provided, level 2B and level 3 documents appeared to be of less relevance than level 2C documents. That said, the FTT was entitled to believe these documents were of some relevance. So you have the UT there saying that 2B and others, but 2B documents are of some relevance, which, by the way, is not what I think Barbara Mosedale said at all. But anyway, that's what the UT says. But then they go on to, at 92 to say, but we're still not going to order disclosure because we think as a case management decision, it was okay for the FTT to say that they shouldn't be disclosed. And I wanted your submission on that because if your litmus test, as you've said to us, is relevance, it seems to me that the UT was accepting there was some relevance to be attached to these 2B documents. And I could make the same point on level 4. I think it's at paragraph 96, 95 and 96, where they seem to accept that level 4 is relevant or sufficiently relevant. So what's your submission on that?
My submission is that and we will need to go to the First Tier Tribunal decision because it's paragraphs 44 to 47, and in particular, if your ladyship might have in mind paragraph 46, where Judge Maysdale said
Because they're not relevant.
that they are not relevant.
So
but
did the UT make a mistake here, or is it to
Well-
be set aside, or what's your submission on it?
It's the upper tribunal rightly recognises the risk of going back to earlier in their decision, and this would be at paragraph 37, page 43. They were well aware, as this court is aware of the principle, that in a case management decision, the first tier tribunal judge has a very wide degree of discretion, and it shouldn't be disturbed on appeal unless it's unjustifiable.
But do you think that is that your submission? Because I'd understood your submission to be, if the documents are relevant, then it's game over. Then we accept that they need to be, that HMRC can legitimately put them in their list of documents and they need to be disclosed.
It's that is my submission, but the first tier tribunal, 44, 47, in particular 46, Judge Maysdale says they're irrelevant. But coming and staying with the upper tribunal, and it's this point here where they say 91. Therefore, level 2B and level 3 documents were of some potential relevance, even if that relevance was not immediately obvious from the parties pleaded cases. And of course, as we've seen from the case law, Randall, it's a matter of practical judgment, and
But we know why that is. That's because, as the UT has explained in the passage you took us to a moment ago, the FTT had looked beyond HMRC's statement of case because there was no statement of case from either Mr. Bell or Mr. Mitchell. The FTT had therefore taken into account the oral explanations that had been given, and the UT said that they were entirely justified in doing it. The FTT was entirely justified in doing that. So is that not the explanation of what's said in 91?
well, that they say in 91, the FTT was entitled to take a middle ground. This is the final sentence. The FTT made no error of law in taking middle course and linking the extent to which those documents were properly included on HMRC's list of documents to the extent to which they reference companies referred to in HMRC's statement of case. And that's why the upper tribunal and indeed the FTT spent so much time on HMRC's statement of case, because it's looking at the validity of the PLNs as a matter of fact. When it comes to the substantive hearing, who are the relevant companies and individuals, in order to focus in on that question of who is a shadow director? What evidence is probative of saying that either Mr. Mitchell or Mr. Bell is a shadow director? Now, if you look at what HMRC were seeking...
Well, before you go off onto that, can we just stick with my lady's question? So, first question I'd like to ask is this. Am I right in thinking that you've got no respondent's notice saying that the UT's decision should be upheld on the basis that they were simply wrong to say that the document's relevant at all?
My lord, there is no respondent's notice to that effect.
Right. So, as my lady's pointed out to you, the UT has held, in relation to both categories of documents, that there is some degree of relevance. Now, if the criterion is relevance, why does it not follow that there's nothing to stop HMRC voluntarily producing them?
But they recognise within those paragraphs that the FTT was not plainly wrong to reach that decision.
But look at the reasoning in 91. Having said that the documents, this is level 2B, were of potential relevance, they said the FTT had to decide as a case management matter the extent to which they should be included on the list. One extreme, the FTT could have decided that since the documents were all, and I emphasise the word all, of some potential relevance, they could all be included. At the other extreme, it could have required the relevance of each document to establish individually, and it took no made no error of law in taking a middle course. But if the criterion is relevance, how does that reasoning stand up?
Well, I think if I was respectfully submit, it's then important to go on to paragraph 92 of the UT decision. And they say Mr. Bell's objection to the FTT decisions regards level 2B, level 3 documents is in effect that he has been deprived of such documents that might potentially help his case or harm that of Mr. Mitchell. Moreover, he complains that he has been deprived at an early stage of the proceedings. The argument would have had more force if his or Mr. Mitchell's cases had been included in more detail. However, as matters stood, Mr. Mitchell and Mr. Bow had given few particulars, even though factual matters relevant to the question whether they were officers of the universal companies or whether the VAT inaccuracies were attributable to them within their knowledge. Mr. Bow had not mentioned in his grounds of appeal to the FTT that he would be making the positive case that Mr. Mitchell was responsible for inaccuracies in the universal's VAT returns. The FTT was not plainly wrong in declining to give Mr. Bell sight of all level 2B and level 3 documents when Mr. Bell's own pleaded case lacked some relevant details. In any event, we do not agree that Mr. Bell has been permanently deprived of relevant documents.
But what's your submission to us? As to level 2B documents, are they irrelevant or relevant?
They're relevant to the extent of Judge Mosedale's decision.
Judge Mosdale, I think we're going to come to, said they were irrelevant. I mean, I think there's a complete lack of coherence between the FTT and the UT on this.
She said, Judge Mosedale says, this item, this level of relevance, in terms of any mention of interaction between universal companies or either of them with other companies controlling or allegedly controlled by Mr. Mitchell and or Mr. Bell, is only relevant and admissible to the extent that reference is made in the statement of case.
You could say, I think, perhaps fairly, but not necessarily correctly, that there's just some very loose wording with respect to the upper tribunal in paragraphs 90 and 91, and the statement of the FTT was entitled to conclude these documents were of some relevance is just loose language of saying some of the documents were of relevance, namely those linked to the statement of case, and others were not. And that links with the statement in 91. It could have required the relevance of each level 2B document to be established individually, etc. So that's something you could pray in aid, I think, at least as an argument, that they were sticking. What really matters was what Judge Mosdale decided, because that's what they were endorsing.
So she said that some of them weren't relevant. I mean, as I read the upper tribunal, they were saying, well, they were a bit relevant. She was entitled to the case management thing.
Yeah.
And the only other companies outside of universal companies that are referred to are Marion and Arian Services.
In the statement of case?
Yes.
So there were other companies in the group like that that Mr. Mitchell was connected with. Wasn't that the point? Wasn't that the point? The other bits of 2B evidence.
But if let's assume Judge Mosdale hadn't imposed the limitation that she did impose, but then begs the question: well, how broad is that inquiry? Is any mention of interaction between the universal companies or either of them, or anything controlled or allegedly controlled by Mr. Mitchell or Mr. Bell? That may well be quite a lot of companies, which may not be part of a proper corporate group. It only makes sense, in my respects, submission level 2B, if it's read with Judge Mosdale's limitation, which is any company, any entity which is identified in the revenue statement of case.
Okay. All right, I've got that. That's very helpful. Thank you. Can I press the same points in relation to level 4, where Judge Mosdale didn't split it, I think I remember rightly, but she said that all of level 4 was irrelevant.
That's right, Judge.
And then you get to 95 of the upper tribunal, where they talk about it in terms of the penultimate line of sufficient relevance, penultimate line of 95 and 96.
That's...
So again, what's your submission? Who's right? Irrelevant or sufficiently relevant?
My submission is Judge Mosdale is correct, and this goes to the point which we'll see in a moment, that she said it. If general credibility is an issue, by reference to general pleading dishonesty, straightforward,
then it has to be pleaded with, so it's tried to point to law, particularity and clarity. And Judge Maysdale concluded that there was no such pleading in HMRC's statement of the case. In the absence of that, level 4 documents were not relevant. But of course, you've got within level, in terms of that, you've also got its level 2C, where Judge Maysdale said any mention of interaction between Mr. Mitchell and Mr. Bell, even if in a context outside the universal companies, is relevant and admissible. And I accept Judge Maysdale's decision and her point, which was, well, there's an issue as to who you believe at the substantive hearing in terms of what they're saying. So you want to, a tribunal judge wants to understand what the nature of the relationship is between the two co-appellants. So Judge Maysdale, in our submission, said that's relevant and admissible. You also have level 3, which is not under appeal.
Because there's nothing in there.
That's right, but it's an odd one, because it's any mention in the document which goes to show Mr. Mitchell's interactions with other companies which he controlled or allegedly controlled, and in particular his interactions with companies which had dealings with the universal companies. Now, if that was left without Judge Maysdale's qualification, again, that's very open-ended in terms of a factual inquiry, but Judge Maysdale said only relevant and admissible to the extent it's relied on in HMRC's statement of case. And what Judge Maysdale did as first instance judge was take a common sense approach to her evaluation of the disputed documents, informed by reference to HMRC's statement of case, yes, grounds of appeal, and the submissions. But in our respectful submission, each of those levels makes logical sense because it defines and confines what documents are admissible by reference to the issues of fact. And in any litigation, as this court will well appreciate, there needs to be limits on litigation, and that's by reference to relevance and admissibility. Would this be a convenient moment to go to the First Tier Tribunal decision?
Yes.
Thank you, my lord. Core bundle, tab 8, page 75. And we say Judge Maysdale's decision is right. You can see paragraphs 1 to 7. She sets out the nature of the relevant background, procedural background. PLNs has in mind paragraphs 3 and 4. In particular, paragraph 3, PLN legislation, which is looking for shadow and de facto directors. Paragraphs 8 through to 11 deals with the part of proceedings to be dealt with in camera. 12 and 14 deals with publication of the decision. Page 78, documents in dispute. Paragraphs 15 to 17. The judge is quite clearly aware of the scope of the listed documents, and the judge comments at paragraph 16. Mr. Aitken for Mr. Bell concurred with HMRC's position. He did not ask for disclosure of anything HMRC had agreed with Mr. Mitchell they would not rely upon. So, from Mr. Bell's perspective, he's aligned his position with that of HMRC, and HMRC, in advancing its submissions on the disputed documents, will of course have been advancing a position as to why, in their view, the disputed documents are relevant. But in our respectful submission, that protects the interests of Mr. Bell, because at that point their interest is aligned. In terms of the legal principles, the judge properly directed herself as to the law in our respectful submission. Paragraph 19, the judge deals with Rule 15.2b.
Just on that question, sorry to interrupt.
Sorry.
Did Judge Mosdale refer anywhere to Section 18?
Yes, my lord.
I mean, I appreciate she quotes it at paragraph 20, but I mean, in terms of the reasoning?
Paragraph 22 to 23. And actually 24 by way of conclusions to approach.
So you'd accept the first 3 lines of 22 as correct in law, that HMRC don't need to get an order from the tribunal if they want to make a Section 18.1 disclosure. So if that were the way this was properly characterised, HMRC could and should just have got on with it, as Mr. Pusey says.
Yes, but HMRC, in our respect for the submission, rightly asked, when we saw the list of documents, perhaps the detail of the correspondence isn't important, but as soon as we saw the list, we made an application promptly to protect the interests of our client. But of course, you may have some taxpayers who are not legally represented or are represented, and they may not have any issue with what is on HMRC's list of documents. But this goes back to the point also which was raised and commented on in the Upper Tribunal, which is they accepted that the disclosure obligation under Rule 27 would fall away because the FTT had jurisdiction to consider admissibility at that point.
So it's a slightly lopsided submission that you make. HMRC, paragraph 22 is right, and HMRC could have made the disclosure without coming anywhere near. They could have just disclosed the documents without coming anywhere near the tax tribunal, because that's what Judge Mosdale says. But your earlier submissions were you still have a right to object in the FTT to the exercise of a Section 18 power, if, and we read in again the idea the documents which HMRC are seeking to disclose are not relevant. And relevance is tested by reference to what would be admissible as evidence. We've been through that.
Which is arguably how this started out.
Yeah.
Then, just moving on under the meaning of relevant evidence, respectfully submit the judge directed herself correctly in terms of Randall on admissible evidence and what's relevant. Mr. Chapman, representing HMRC, put forward the submission something potentially probative was relevant, but the judge said that's just a more succinct way of saying that relevant evidence is evidence capable of increasing or diminishing the probability of the fact in issue. Then you have paragraph under the relevant evidence to be excluded. This is paragraph 11 in infinity distribution, which this court has already seen. In paragraph 27, while all taxpayer material was confidential, in this case it was agreed that the disputed documents in this appeal included a lot of material prejudicial to Mr. Mitchell, and which he would not wish to see in the public domain. It was Mr. Mitchell's position that where the disputed document contained relevant and irrelevant, confidential and prejudicial material, only the relevant should be admitted and the irrelevant redacted. HMRC agreed with that in principle. They did not suggest that this was a case where the irrelevant material should be admitted because it would be too onerous to spend time disentangling it from the relevant material. Then 28, for your note, under the heading relevant material to be excluded, judge again correctly refers to IA associates, new GJ as he then was. One starts with asking the question whether the evidence is admissible. It's admissible if it's relevant. If it's relevant, it's potentially probative. One more of the issues in this case. One then asks, notwithstanding its admissible evidence, whether there are good reasons why the court or tribunal in this case should nevertheless direct it to be excluded. 30, all relevant evidence should be admitted unless there's a compelling reason to the contrary. 31, I don't think we need to dwell on, but having set out the relevant legal principles, which no party disputes, Judge Mosdale has adopted, we then get on to the application of those principles to the facts. The issues in the appeal from 33 through to 34, the judge considers the appellant's notice of appeal, statement of case 34, and then the judge goes through the division of documents in levels.
Can I just pause, because it appears that, having looked at the upper tribunal decision, that the issues were identified by reference not only to the statement of case, but also to the explanations given as to how the appeals were likely to be run from the taxpayer's point of view. Where is the best place in this judgment to find a record of what explanation was given in that regard?
That will be...
61's got a little bit of flesh on level
Yes,
4
it's-
documents, but I
it's-
can't find a sort of a statement, the oral explanations that were given by counsel, presumably. There
Yes,
isn't a record of them, is there?
It's that section, and sorry, I'm looking for the reference where it refers to a cutthroat defence, which, if I may, I'll ask my junior to
Yes, certainly.
pull out the reference. Sorry, I should have that.
No, no.
33.
Thank you.
33, and thank you. I'm obliged to.
2 please.
Yes, there was no mention, also mention 33, there was no mention of anything approaching a cutthroat defence, but it is clear their interests are not aligned, as Mr Mitchell objected to disclosure of the disputed documents to Mr Bell, as well as objecting to HMRC's reliance upon them. And then you have at paragraph 37, where Mr Chapman, representing HMRC, with some adoption and refinement from myself, the judge then set out the levels agreed upon, and then you have levels 1, 3 to 4. The only appeal in these proceedings in relation to level 2B and level 4. So if we go directly to level 2B, page 82, level 2B was any mention of interaction between the universal companies or either of them with other companies controlled or allegedly controlled by Mr Mitchell and or Mr Bell. The judge clearly has, obviously, the level of relevance in mind. 45. Mr Hickey's position was that this material was irrelevant as HMRC's statement of case only pleaded that Mr Mitchell and Mr Bell were shadow directors of the universal companies. HMRC did not plead that companies which Mr Mitchell controlled were shadow directors of the universal companies.
So, as it's recorded there, the submission was relevance was confined to HMRC's statement of case.
My lord,
That's
yes.
no longer your position.
On level 2, the only submissions, well, my position is that it is the revenue statement of case.
So you retract what you said earlier
Well, Mr.
several times, which was that relevance was not confined to what was in HMRC's statement of case. Because you will remember I asked you several times,
Yes.
if it wasn't restricted to the statement of case, what was the limit? And ultimately you said, well, it was all a question of fact.
I certainly don't detract from that, my lord, because paragraph 33, the judge correctly reflects the point that she considered their notices of appeal and the cutthroat defence which was being advanced.
But the reason I'm asking the question is that it appears from paragraph 45 and it appears from the subsequent reasoning that the submission that was advanced to Judge Mosedale, and which she appears to have accepted, is that relevance was to be judged and judged only by reference to HMRC's statement of case. And that seems to be inconsistent with your acceptance before us that HMRC's statement of case is not the be-all and end-all.
It's the relationship between the taxpayers and HMRC seeking to, well, in Mr Mitchell's case, defending against the PLN, and it's by reference to what HMRC say in their statement of case. And the court issues relied on by HMRC in their statement of case, there's no case advanced in relation to other companies owned and or controlled by Mr. Mitchell and or Mr. Bell, other than those two companies which I identified, Margall and Arion Services, which is why Judge Maysdale imposed a limitation on 2B that she did. But it's relevant, but only to the extent an entity is referred to in the statement of case.
So that is treating the statement of case as determinative.
In her evaluation of the issues on that particular point, yes.
So it's difficult to see where the upper tribunal got its impression or finding from, that the First Tier Tribunal took into account the explanations for the purpose of assessing relevance.
Yes, certainly within paragraphs 44 to 49.
Seems to be a complete
It is
mismatch
based
in a
solely
number of
on-
stages.
Sorry, mate.
No, my fault. Don't worry. Yep.
I won't seek to read out what's at 44 to 49. There's one important point that I should raise, which is obviously this court has seen within paragraph 46 and paragraph 48 in italics a sentence redacted at least temporarily, and in 48 remaining part of the sentence released redacted. You do have within the disputed document bundle the unredacted decision.
I found that.
And then in relation to level 4, page 83, level 4 was anything which went to Mr. Mitchell or Mr. Bell's credibility generally.
Sorry, can I just go
Sorry.
back? Very sorry to do this to you, but paragraph 49, I just wanted to be quite clear what paragraph 49 is saying. So Judge Mosdale is saying to the extent that the disputed document contains mention of those two companies referred to in the statement of case, then those documents are relevant. And I take from that, and I think we can all agree, that the rest of 2B was irrelevant. In other words, she concluded that if it didn't contain mention of those two companies, it wasn't mentioned of those, then it was irrelevant. And as I understand it, that was her reason for saying, I'm not going to let this come into the list of documents because it's irrelevant.
Yes.
And that's, as we've been through what the upper tribunal said, but it's arguably differently put in the upper tribunal.
Yes.
Okay, thank you.
On page 83, level 4, paragraph 59. Level 4 was anything which went to Mr. Mitchell or Mr. Bell's credibility generally, and in particular the credibility with which they presented the affairs of companies which they controlled or allegedly controlled. Mr. Hickey's case is that this is not relevant. Mr. Chapman said it was relevant as Mr. Mitchell's credibility was an issue, 61. I find that Mr. Mitchell's credibility is to some extent an issue. It is expressly stated in the statement of case that HMRC do not accept the credibility of all that he has said to them in respect to the universal companies. It is not expressly stated in respect to Mr. Bell, but it is clearly implied. HMRC consider he knew about the inaccuracies in the universal companies' VAT returns, and Mr. Bell denies this. HMRC allege he deliberately procured the inaccuracies. Mr. Bell denies this. I find both appellants' credibility in respect to what they say in regards to the universal companies in issue, and they know this. But there is no statement that their credibility in general is an issue.
What does the judge mean by that?
My lord. Sorry.
I just don't understand what that sentence means. I mean,
The final sentence of paragraph 61.
no, the sentence in paragraph 62 that you just read out. There is no statement. Their credibility in general is an issue. What does she mean by that?
Well, this is...
She's just recorded that their credibility as regards the universal companies is an issue, and they know this.
This is, I think, refers back to paragraph 59, which is the general level 4.
I mean, is what Judge Mosdale's saying there that she's looking for a statement in HMRC's statement of case and not finding a statement saying Mr. Mitchell lies about everything? as was famously said, I think it was, I can't remember who the author of the statement was, but the subject of it was Lillian Hellman. It was alleged that every word she said was a lie, including the words and thee. Is that what Judge Mosdale is looking for here?
It's a point, I think, that their general credibility is an issue in terms of their wider character. And this was the point which is picked up by the upper tribunal when they referred to the Court of Appeal's decision in relation to specific disclosure on level 4. I just turn that up. This is their page.
But I'm sorry, before we get on to the question about specific disclosure, and of course I understand that point, but I'm just wondering what it is that is missing from HMRC's statement of case. Is it suggested that they should put in a plea to say Mr. Mitchell should be disbelieved on oath regardless of what he says? Is that what we're expecting to see?
I think it's developed further by what Judge Mosdale says at paragraph 63. She says, I consider HMRC need to be reasonably specific in the pleading as fraud requires particularity in pleading. In the absence of 64, in the absence of any pleaded case that Mr. Mitchell's statements about his other tax affairs were unreliable, I find level 4 material not relevant. So it's in that context that she's looking at level 4 material.
I'm sure my lord wants to just come back on that, but just for the moment, can we finish off my point, which is that what Judge Mosdale says, i.e. not relevant, is really very different from what UT say, which is a bit relevant. And I think I reported your submission as well. In fact, your appeal, your respondent's notice, I've just looked at it, says you want to uphold the upper tribunal for all the reasons it gave. But I think your response to me just now is that you rather prefer the FTT's findings on this to those of the UT.
In our respondent's notice, well, we went further and we
You did go further, but amongst other things,
Yes.
you do say
yes, we do.
UT was right for the reasons it gave.
We do. We say the FTT was spot on in terms of the point of pleading fraud generally requires particularity and clarity. And the judge was entirely right to say that in looking at the relevance of level 4 documents, there was no... It was open to the revenue in their statement of case. If this is the view they have of Mr. Mitchell, they could have said, I think it's paragraph 47, where they plead out about 9 points relating to why Mr. Mitchell is a shadow director. It is all confined to either being a shareholder, either shareholder had a relationship with the Universal companies, they rely on Mr. Bound's interview. There's one reference to Mr. Bounsell, former accountant, as all the primary reasons they rely on to say this is why Mr. Mitchell is a shadow director and is responsible for the tax errors. They haven't pleaded more widely, and they could have brought his general character into issue in terms of other aspects of his life if they thought that was relevant to their case, but they haven't done any of that. So, to respectfully say, Judge Mosdale was right in her succinct analysis, 59 to 64, to adopt the decision she did.
I'm obliged to my lady for drawing attention to the terms of your respondent's notice, because I take back what I said earlier. I think, in fact, you do take the point, because if we look at the respondent's notice, this is tab 12 of the core bundle, page 115, paragraph 6.5, and it's the last sentence that's key for this purpose, where you say there, the disputed documents are only relevant in the missile to the extent that, and the key bit is the parenthesis, which is the decision of the FTT. And then you go on to refer to the individual levels. So I think on a fair reading, you are there saying that the decision should be upheld for the reason given by the FTT as to relevance. So I think procedurally your tackle is completely in order. You have the respondent's notice on that point. But can I ask you about the preceding sentence? Because that gives the basis for this contention, where you say, this is because no documents are disclosable unless facts and or allegations are pleaded in HMRC's SOC.
Yes.
So the basis upon which you invite us to uphold the FTT's decision is that the FTT assess matters exclusively by reference to HMRC's statement of case and was correct to do so.
My lord, yes.
But earlier today you accepted that relevance was not to be judged exclusively by reference to HMRC's statement of case. So which is it?
I said earlier this morning that I made no complaint about the approach taken by Judge Maysdale as a first instance judge dealing with a case management issue. And my submission was that, and it is, that first and foremost it is the revenue statement of case, that I cannot say that an FTT judge is not permitted to take into account what is in the grounds of appeal and what the parties have submitted, because the FTT has control over its own case management jurisdiction. But I say front and centre, it is the statement of case, because that is informed by what everything else has gone before it. I won't impose on the patience of the court by repeating those points.
Thank you.
I don't have any further submissions to make on level 4. Just in the context of our skeleton argument, which you will have in the full bundle, at tab 11, which is page 93. My focus when I first stood up was in relation to submissions on section 18 of the 2005 Act, and then that's obviously developed in a variety of different directions in response to your lordship's questions. But I'm just obviously conscious of time, and obviously we need to allow others to make submissions, but just looking through my skeleton argument in terms of setting out our position in relation to the law, I think I've gone through page 99, and your lordships will have this, and ladyships will have this well in mind, the threshold for an appellate court to intervene. I've dealt with the essence of HMRC's statement of case. Page 101, I've gone through the legislation relating to PLNs. Page 102, paragraph 32, I've dealt with Burns, appeal, the need to plead with particularity and clarity, obviously a tri-point of law. FTT powers, we've discussed paragraphs 38 through to 41. You've heard my submissions on how the FTT and our respectful submission should approach those issues, and I've dealt with that by reference to admissibility, relevance. One point on page 106 I've touched on, which is in relation to specific disclosure applications, and I've referred the court to the upper tribunal decision in Kevin McCabe, and perhaps just to make you aware, in the legal authorities bundle.
Just before you go to that, can I ask this question? What's the relevance of that, given that we're not concerned here with an application for disclosure at all, let alone specific disclosure?
My lord, it's commented on in the context of the upper tribunal's observations about specific, that it was open to Mr. Bell, if he wanted to, in due course, to make an application for specific disclosure. And they said in relation to level 4 that they noted it would be effectively unlikely that any application would succeed in relation to general character.
Well, that may be so, but what's the relevance of that?
My lord, it has no relevance to this appeal.
Right.
Then at page 108, and I think we've covered this ground, our submissions on level 2B, and page 110 on level 4. Unless I can be of any further assistance to your ladyships and your lordship on any particular point.
Thank you very much.
No, thank you very much for your submissions, and I'm grateful for your patience in dealing with the many questions that you've had from the court.
My lord, not at all.
So, Mr. Pusey, I think for you to reply first.
Thank you, my Lord. The submissions on relevance we've heard today show the perils of applying a test of relevance to a list of documents compiled at an early stage of the proceedings. It's a recipe for dispute by parties who are not fully informed as to the facts and matters in issue in the appeal. There is a power to disclose the documents that HMRC sought to disclose under Section 18, and there is no right to challenge that save through judicial review.
To what extent might one read Section 18, subsection 2c down by reference to relevance? So, given the primacy of confidentiality as reflected in subparagraph 1, could it be said that C should be read down in some way, so it's got to be disclosure, relevant disclosure made for the purposes of civil proceedings?
Confidentiality and relevance aren't two concepts that necessarily go together. Section 18 is carefully framed as to when and why HMRC can make a disclosure. So under Section 18.2a, it is for the purposes of a function of HMRC. 2c, the purposes of civil proceedings. To introduce another criteria, words that aren't there, documents that should be disclosed for the purposes of civil proceedings, which are relevant. Relevance is a difficult concept to apply at an early stage of the proceedings.
Yes.
When sometimes objection is taken to documents in the tribunal, the tribunal says, well, we'll consider that when we've heard all the evidence. Then we'll be able to form a judgment as to what is relevant or not.
And as you said a moment ago, confidentiality and relevance are two different things. I mean, a document may be simultaneously highly confidential and highly relevant.
Yes, absolutely.
But do you say that a proper reading of the legislation is to the effect that Parliament contemplated an unfettered, subject to public law control, right on the part of HMRC to breach confidentiality by disclosing irrelevant documents?
No fetter on disclosure, trusting to HMRC within the words of Section 18, which give very specific reasons why HMRC can make disclosure. So Mr. Hartnett was not permitted to speak to journalists about taxpayers' affairs in Ingenious.
Even though, of course, he tried to make it confidential.
Yes.
So even his confidentiality club didn't get in the way of the basic principle.
No, no. One word on Ingenious. Supreme Court expressly at paragraph 25 said that they were not deciding the ambit in general, section 18. They were dealing with that specific situation. They weren't.
So, Mr. Pusey, where do we get to? I think in answer to my lady, you suggested that it wasn't quite an unfettered right, but that relevance wasn't read in.
Yeah.
So we are in the territory, are we, where I'm just trying to work out where this takes us. Is it sort of care and management type
Yes.
boundaries on what they can do? So it has to be a legitimate exercise of
Yes.
statutory power and so on.
I'm trying to think of an example in this case. If, I don't know, if Mrs. Mitchell, if there was a Mrs. Mitchell, if HMRC sought to disclose her tax affairs for no other reason than she was married to Mr. Mitchell, it might be said that that would be an irrational approach.
Yeah, I mean, for your purposes, we don't need to explore the boundaries because Mr. Hickey accepts that HMRC's belief that these documents have some relevance to the issues before the tribunal is not an irrational one.
Yes, yes. This case isn't really about disclosure. It's about documents that one party wishes voluntarily to disclose to another who doesn't have them. It's not about admissibility. And the distinction is drawn in the White Book between disclosure and admissibility. And we have that within the authorities bundle. It's the penultimate tab 24. Page 335. Yes, 335. .6.6.
Yeah.
That really should be the answer to this matter. The exercise that the First Tier Tribunal was taken down, the route they were taken down, was fraught with peril from the outset. What the Commissioners had the power to disclose, confusing disclosure with admissibility has caused this case to come before this court, but it shouldn't have done. This case is different from most appeals. It's more akin to a fraud prosecution where HMRC alleged that two individuals are responsible for deliberate inaccuracies in the VAT returns of two companies. HMRC must prove that, and these appellants are facing a potential penalty of £6 million each. That figure could go up or down depending on the extent to which the FTT finds either or both responsible for the inaccuracies. Each appellant blames the other. They're running a cutthroat defence. HMRC has pleaded reliance upon what Mr. Mitchell has said about Mr. Bell.
Why did Judge Mersdale say that there was no mention of a cutthroat defence? We looked at that, didn't we?
Yes.
Earlier.
Sorry. I'm sorry, Mark. Yes. but good. Yes, paragraph 33.
Yes.
The tribunal says nothing approaching a cutthroat defence, but in the upper tribunal, something it's almost the opposite is said. Sorry, man,
It just seems to me that,
paragraph 61.
yes, this this misunderstanding, if misunderstanding it was on the judge's part, may have been important. May not, but it appears.
Yes. Yes, I'm sorry.
So reference is made to paragraph 53 of the FTT decision.
Yes. Well done, yes, so that is reference to a cutthroat defence.
Yeah.
Yes. Each defendant blaming the other. And at paragraph 61 of the upper tribunal, that is quoted again.
Thank you.
Thank you. In circumstances where HMRC rely on what Mr. Mitchell has said about Mr. Bell, it's entirely appropriate and to be expected that Mr. Bell would seek disclosure of everything that Mr. Mitchell has had to say in connection with his tax affairs. And we see that Mr. Bell has not simply hung on the coattails of HMRC. He has, in his skeleton argument, submitted additional reasons why disclosure should be made. This was the skeleton argument that was submitted to the First Tier Tribunal, tab 10 of the supplementary bundle. At page 89, paragraph 4.2.1. Sorry, 4.2, in addition to the grounds set out at HMRC's application, PB argues, and then submissions made on relevance. At 4.2.1. And also over the page at 4.2.4. So if the First Tier Tribunal was to take account of the representations of all parties, it would see what Mr. Bell was submitting there, which went somewhat wider than HMRC's pleaded case. It has been the Commissioner's consistent position that Mr. Bell should have what may potentially assist his case. I appreciate that Commissioners did not appeal the First Tier Tribunal's decision, nor the Upper Tribunal's decision. But the position throughout, and this is recorded at paragraph 30 of the Upper Tribunal decision, has been that Mr. Bell should receive documents that may assist him. And if we come back to the notice of appeal for Mr. Bell that we looked at this morning, we saw there his expectation that he would be provided with the COP 9 material relating to the inquiry into Mr. Mitchell. My Lord, my ladies, I don't think there's anything else that I can add unless there are any questions.
Just one further question. You've given us your reply on section 18.
Yes.
Could I ask you for your response to the submission made by Mr. Hickey with regard to the power of Mr. Mitchell to prevent HMRC exercising its powers?
So
You have said earlier that there's no right to challenge that by judicial review, and I just want to be clear, therefore, as to the implications of that. As I understand it, therefore, you are saying that it is not correct that the FTT, upon application by Mr. Mitchell, has power to prevent that under either Rule 15(2)(b)(3) or Rule 5(2).
that's correct, my Lord, for this reason. Rule 15(2)(b)(3) is concerned with admissibility, not with disclosure. And it provides a very specific reason not to admit evidence because it would be unfair. Not because it is at that stage in the proceedings seen as irrelevant. Parliament has entrusted the Commissioners under Section 18 with a wide discretion, and if they're purporting to act under Section 18, then one would have expected a very specific provision allowing the tribunal to effectively curtail that. That doesn't exist under Rule 15. It certainly doesn't expressly exist under Rule 5. The tribunal has wide case management powers and can regulate its own procedure and regulate what evidence it receives. This isn't about regulating what evidence is received. It's about regulating what material may be provided by the Commissioners to somebody else. So we get back to the confusion between the admissibility of evidence and disclosure.
Well, it's not even disclosure on your submission.
No.
It's voluntary production.
But yes, the provision of documents. Yes, I've used that term, disclosure, loosely.
Yeah.
On the appellant's case, it can restrict what another appellant may see by reference to HMRC's pleadings.
On Mitchell's case, you mean? That appellant?
Yes. By reference to HMRC's pleadings, even though HMRC rationally believe that the material may assist the other appellant. And to introduce the statement of case into this process as the deciding factor is actually to introduce a non sequitur. This isn't about HMRC's case, it's about the provision of documents which HMRC rationally consider another party should have.
Mr. Pusey, before you sit down, don't sit down. Just to clarify then, you say that HMRC was in fact proposing to use Section 18 powers. Is that how we should look at this case? It ended up listing things on a list of documents that went to the FTT, but we've been round that house. In terms of what was actually going on, was this question mark HMRC simply proposing to what was your word, provide material to a third party?
Well, they were providing it under Rule 27.2 because that's the direction that requires them to file a list of documents. That's the provision that requires a list of documents. But of course, Rule 27.2 says, provides that a list shall be made of documents that are either relied upon or are to be provided. And so that provision echoes what is in section 18. I'm afraid I cannot submit to the court that somebody sat down and thought, this is section 18 territory rather than Rule 27.
Okay. But you'd say there is, when they think about this, that there's a point at which Rule 27, that bit about, that goes beyond just listing documents, it talks about providing documents. That needs to ally with, or at least reflect, section 18 and the extent of HMRC's powers, when you're looking at HMRC's list of documents anyway.
Yes.
Okay. All right. Then I've got your submissions on board about relevance not being the test. It's something closer to rationality, but we have to bear in mind the duty of confidence as well. And Ingenious gives us a bit of help on that. But you say that it's not a test of relevance in terms of what HMRC may or may not wish to provide under section 18.
Yes.
So you look at section 18.2, gateways. What do you say, just to pick up the point about what the FTT said, because the FTT said, when we come down to the nuts and bolts, looking at the levels they looked at, the FTT said that part of the 2B level was irrelevant and the whole of the category of level 4 was irrelevant. Do you challenge that and just say they got that plain wrong because they were obviously relevant documents?
Yes. Having seen some of those documents, I could give page references. In the unredacted bundle, tab 34, which is actually the third item, page...
Are we in the supplemental bundle?
This is in the closed bundle.
The
unredacted, yes.
Which the Judge Mosdell saw?
I understand that she received submissions on those documents.
Some of the hearing was in private, wasn't it?
It was, yes. I confirmed that with Mr. Aiken earlier.
Therefore, we have to be careful about what we say in open court.
Which is why I was simply going to give page references and not. But if one were to go to page 81, which is the introduction of the document, page 83 in particular, there are matters there that would indicate, we say, First Tier Tribunal was clearly wrong in its approach to category 4. And similarly, in relation to category, well, either 4 or 2B, at tab 41, pages 148 to 151.
Sorry, I hesitate to rise. I don't want to interrupt my learned friend's play. I've obviously not made any submissions on the disputed documents, and I don't propose doing so. Could I just note that at tab 2, you do have the transcript of the closed portion of the proceedings, where I do very fully, to the time available to me, went through each of those documents in the disputed bundle, as did my learned friend, Ms. Goldring, representing HMRC.
That's the transcript before the UT.
Yes.
Do we have an equivalent transcript before the FTT?
No. There's no transcript
But
of the FTT.
Can you help us on this? Because I'm a little troubled by that, because you are, by your respondent's notice, supporting the FTT's decision on complete irrelevance of what's in dispute. Whereas the UT, as we've seen, seems to have taken a bit of a different view on relevance. documents. And I wonder, therefore, to what extent we're assisted by the transcript of the discussion before the UT as distinct from the discussion before the FTT.
There is no transcript before the FTT. There was no transcriber. I don't even know if there was.
But maybe the answer is it doesn't matter because the same questions were traversed at both hearings. Is that right?
I went through the documents, but there was a certain passage in time, including obviously the pandemic. So I can only draw this court's attention to the fact that the transcript with submissions on the documents. I just obviously feel it's important to make you aware of what our submissions are on various documents in the text.
Yeah.
Yes, I've dealt with it. We've dealt with it. I was only really putting to Mr. Pusey the point that I've already put to you.
Yes, sorry.
And that we've debated about whether the 2B and 4 findings were right or wrong. And I think what I've written down is that you'll take the FTT and the UT and put them in the alternative. Either they were irrelevant or they were relevant and it was permissible to exclude them on a case management basis.
Yes.
And Mr. Pusey, as I understand, he says they were just plain relevant, and you can't say the case that you can exclude them on a case management basis because we're in a different territory of HMRC with its powers of disclosure. Provision, not disclosure.
It was just in fairness to my client, I wanted to make sure the court had the flavour of our view on those documents.
Thank you.
Sorry,
Perhaps of assistance.
nothing else. Lady, is there anything else?
I don't think there's anything from me. Thank you very much, though, for your help.
Thank you. Thank you.
Striking.
Well, I'm not going to detain you for very long. First of all, I would adopt as part of my reply everything that Mr. Pusey has said with one exception. That exception relates to the documents that are in the restricted bundle. I haven't seen them, so I can't support his submission, although I'm very pleased to hear it. I will, if I may, take you very, very quickly to the First Tier Tribunal decision, page 76, tab 8 of the core bundle. A very short point indeed. The FTT clearly was aware of the cutthroat nature of the defence. Paragraph 5. Mr. Bell and Mr. Mitchell are separately represented, and the interests are not aligned. It seems it is Mr. Bell's case that if either of them was responsible, it's Mr. Mitchell who ran the companies and was responsible for any irregularities which occurred, while Mr. Mitchell's case appears to be that the reverse was true. I don't think that's been cited to so far.
Right, and that's consistent with what's said in 53 about blaming each other. So as I understand it, what that implies is that the comment about cutthroat defence in 33 is purely directed to the notices of appeal.
Yes, well, I think that must be correct.
Yeah.
I think it's fair to say that there's a slight difference in Mr. Mitchell's position, and Mr. Hickey can respond to this if necessary, that I don't think he blames Mr. Bell. I think his position is that he was not responsible.
But it might be said there's an implication.
Indeed, there might, but we're at such an early stage in the evidence in this case.
I think his notice of appeal simply says that, doesn't it? Isn't it Mitchell who puts in the short notice of appeal, and Bell's is a bit longer?
Yes, but Mr. Mitchell's effectively says nothing at all, simply that he has not had an opportunity to challenge.
Yeah, but the HMRC statement of case relies upon evidence given, a statement made by Mr. Mitchell in the course of the COP9 investigation, effectively blaming Mr. Bell.
Yes, that's absolutely correct. The only point that I really want to draw out in this reply is there's been much talk, understandably, about the relevance of HMRC's statement of case. However, there is no requirement for a statement of case from the appellants.
Yet.
Well, Lord, it's not the practice for there to be such a statement. What tends to happen is either that the grounds of appeal are with permission amended, which happens from time to time, or the matter comes out through witness evidence.
Well, if that is the practice, it may need to be rethought, because one would have thought in a case like this, it would be helpful to all concerned for the FTT to direct service of statements of case by each of the appellants. Because otherwise, how on earth do the parties know what issues to address in their evidence?
Well, the way it tends to work, forgive me, I will be corrected if I've got this wrong, but I don't believe that I have. The way this tends to work is that we have a broad church of taxpayers and appellants, ranging from very...
Yes, of course, and I appreciate, the FTT procedure is not intended to be as formal as a court procedure. I understand that. And in many cases, the formality of a statement of case won't be required. In particular, the normal situation where it's just one taxpayer and HMRC, usually it will be clear enough from the decision under appeal and the grounds of appeal and HMRC statement of case, what evidence, if any, is needed to be required. But this is not the typical case.
Indeed, my lord, this is a very unusual case. Cutthroat defences in tax cases, in my experience, are very few indeed. But
Mr. Aiken, isn't the reality of what will happen is that when everybody will settle down and look at the pleadings, and if anybody feels they don't know the full story, they will seek further and better particulars. That's what tends to happen. So you, at that stage, get an amended appellant's notice, grounds of appeal. But you do quite often just take the witness statements as containing the case that is to be put.
yeah, yes, maybe that's absolutely right. It's very frequent that the witness statements do all the heavy lifting. The point that I wish to start and finish on is the idea that the revenue statement of case could be the be-all and end-all of the question of relevance. In the context of a case such as this, where the statement of case does not contain all the allegations that are flying around, in particular the ones between appellants, it simply makes no sense for the question of admissibility to be looked at this stage. It's far too early.
Yeah.
Well, you already have my skeleton argument, and Mr. Pusey has actually drawn brief attention to it. There's nothing more that I wish to say unless I can help the court further.
No, thank you very much. Well, thank you to all counsel for their very helpful submissions and for their patience and fortitude in putting up with the questions from the court. You've given us a lot to think about, so we will be reserving our judgments and we will hand them down at a future date in the normal way. And as I'm sure everybody in court knows, the procedure is that a draft is sent to those on the list that you have provided for the purposes of checking typographical errors and obvious factual mistakes, transposition of names, that kind of thing, not for the purposes of re-arguing the case. And also for the purposes of enabling you to discuss an order between yourselves to give effect to what we have decided and hopefully trying to agree it, or at least, if not agree it, narrow the ambit of any dispute there may be. If you are able to agree an order, so much the better. If not, then please put brief written submissions in and we will decide on paper what consequential order should be made. As I think everybody now knows and understands, in the light of the General Counsel for Wales case, the draft is supplied under embargo, which must be strictly observed, and a breach of the embargo is a potential contempt of court. So this is a serious matter. But hopefully no difficulties will arise in that case as far as that is concerned. Once we have had your corrections and submissions on the draft order, the judgments will be perfected and handed down remotely and no attendance will be required. Thank you again.